Appreciate you all coming to Topeka today for the Joint Committee on the Fiduciary Financial Institutions Oversight. I think we have everyone here. Representative Owens will be joining us on WebEx. What I'd like to do is start to my left, and if you could just introduce yourself real quick and tell us what areas you represent, that'd be great.
Thank you, Mr. Chairman. Nick Hoeisel, I represent Southwest Wichita in the Legislature, 97th District.
Thank you, Mr. Chairman. I'm Senator Mike Fagg from District 14, live in El Dorado, and there's like 10 counties east of there.
Good morning, Mr. Chairman. Thank you very much. My name is Representative Dan Osman. I'm District 48. That's Mid-South Overland Park.
Thank you, Mr. Chair. Senator Jeff Pittman, Senate District 5, from Leavenworth, Lansing, Western Wyandotte, now Baser.
And I'm Senator Jeff Longbine. I represent the 17th District, which is Emporia, which is my, Lyon is my home county, and I go up through Wabaunsee and Pottawatomie County into Gary County and Junction City.
Thank you. I'm Jim Kelly, House District 11, and I represent a large portion of Montgomery County, which is my home county too, and so all contained in just one county.
Good morning. Thank you, Mr. Chairman. Representative Ree Hsu, I represent House District 25, which is a series of cities in Northeast Johnson County.
Okay, and I don't believe that President Masterson is with us today. He had another obligation, but Representative Owens, I believe you are on WebEx.
That is correct, sir. Stephen Owens represents the 74th House District, Heston, parts of Harvey, Marion, and McPherson County.
Okay, thanks for joining us today. Committee, you have in front of you the minutes of the December 7th, 2021 Joint Committee. Give you a minute to review those, and then any amendments or a motion to approve. Representative Kelly.
Thank you, Mr. Chairman. I have in the fifth paragraph down some new language that I would like to add, which is on the back of the report that goes into where we had some discussion on the intent was also for the State Bank Commissioner's Office to be able to decide when the pilot was over and when new other TEFI organizations could apply for a charter. And so I just wanted to be sure that that was included in the minutes. It is in the report.
That is correct. It is in the report. Are there any questions of Representative Kelly on the proposed change to the minutes? Seeing none. Representative Kelly, do you want to make a motion to approve the minutes, including your?
Yes, thank you, Mr. Chair. I would like to make a motion to approve our minutes of the last year's joint committee meeting and include in that the language that's on the back of the form as an addition to the minutes.
Okay, is there a second? Representative Hoeisel seconds. Any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Opposed, no. Motion carries. Thank you. Committee, we will now turn our attention to an overview of the fiduciary financial institutions legislation and laws from the 2022 session. We'll call on Melissa to give us that. Thank you, Melissa.
Thank you, Chairman Longbine. Committee members, if you will take a look, you do have in your packets last year's report on the mint green paper. There will be reference to two of your recommendations in this presentation, and the memo itself is on our canary yellow paper. And just a reminder, this memo summarizes the background information for 3 bills that were passed by the 22 legislature related to fiduciary financial institutions. Those are Senate Bill 337 and House Bills 2489 and 2547. In total, the legislature considered 6 bills. You will see relevant recommendations from your meeting last year that are noted along with other bill status items under background information for each of the 3 bills summarized. Also included in this memo is information regarding a House concurrent resolution that was introduced last session that would have directed, if adopted, a study by this joint committee on the topic of environmental, social, and governance standards, commonly referred to as ESG. Beginning on the second half of the first page, you will see language from Senate Bill 337 summarized. This will be a matter familiar to this committee and its recommendation last year. The bill amends provisions pertaining to the pilot program established within the Technology-Enabled Fiduciary Financial Institutions, or TEFI Act, to clarify and retroactively codify the intended date for the issuance of a full charter to the Beneficient company. The bill specified that on December 31st, 2021, the conditional charter granted under the pilot program shall be converted to a full fiduciary financial institution charter. The bill, as introduced, had a companion bill or mirror bill. That was House Bill 2554, which was introduced in the House Committee on Financial Institutions and Rural Development. And the bill was requested in both chambers by the Office of the State Bank Commissioner. You will see also that the effective date for this legislation was publication in the Register, March 10th, 2022, and you will see printed there the language regarding the subject of legislative intent, and this was the language that was just added to your minutes to clearly state the committee's intentions and item that was included among your recommendations, where the committee recommended and clearly stated that a permanent charter be issued no later than December 31st, 2021, so that practical actions could be taken with the FidFin Fiduciary Financial Institution pilot program and other requirements. And then you'll see reference to those processes that would remain at the discretion of the State Bank Commissioner. The next bill summarized is House Bill 2489, and this is legislation relating to amendments to the TEFI Act and also amending law regarding reporting of elder abuse. This bill reflects, as introduced, the draft that was proposed by the Office of the State Bank Commissioner and submitted to this committee at its meeting last year. The committee recommended that the bill be introduced in both the House and Senate, and that was done in the standing committees on financial institutions. Among highlights from this new legislation, there were updated definitions, changes to fingerprinting requirement, changes to the existing application fee governing documents, evaluation and examination, customer disclosure and services, and authorized activities. The bill also amended the term financial institution within that statute, requiring reporting of abuse, neglect, or exploitation to include certain individuals, to include fiduciary financial institutions. So to add this entity to a list of other financial institutions already required to report. You will see that there were changes to definitions. There were changes regarding the fingerprinting requirements. They were amended to permit the banking board to requiring fingerprinting of any officer, director, organizer, or any other person of the proposed fiduciary financial institution, to remove reference to any other person and remove discretion granted to the board related to fingerprinting associated with certain applicants. On the next page, page 3, you'll also see that there was some language regarding approval of an application for any out-of-state bank engaging in FidFin transactions in Kansas to have separate document and department for handling FidFin transactions. This separate department would be considered a fiduciary financial institution, and it would have all the rights and powers granted to a fiduciary financial institution and owe all those duties and obligations imposed on fiduciary financial institutions as are provided currently in the TEFI Act. You will see language that was added in Section 3, and it removed language specific to the assessment of the initial fee of $500,000, and then made other changes requiring the application fee and setting those amounts. Section 4 related to the application of provisions to the state banking code, that is Chapter 9, and you'll see there's some clarifying language regarding FIDFIN and fiduciary financial institution business, including the ability to conduct FIDFIN transactions by state chartered banks and trust companies. Another change made within this section creates an exception to language regarding conflicts that might occur between Chapter 9 and the application of the TEFI Act. In Section 6, you'll see some language regarding references were removed regarding the evaluation of safety and soundness of a fiduciary financial institution, and instead criteria was updated that had pertained and instead specifies examination of the fiduciary financial institution and requires these conditions to be evaluated: the profitability of a fiduciary financial institution, a fiduciary financial institution's compliance with applicable state and federal laws, and the fiduciary financial institution's information technology systems, policies, and practices. And you'll see additional language on the top of page 5 regarding the profitability criteria. And then also, as I mentioned, also on page 5 is the reporting of elder abuse by financial institutions to include the TEFIs. There were substantive amendments. Those you'll find some of the background information on page 6. At the time of the House Committee hearing, the Office of the State Bank Commissioner's representative indicated that the agency was working with Beneficient on reaching agreement on modifications to the bill's provisions. There were several agreements that had already been reached, and by the time that the committee took action, Beneficient was no longer an opponent to the bill, and the agreement moved forward. And when testimony was offered in the second house, there were no opponents to the legislation. Among some of those changes from the bill that you saw last year in December, it removed provisions that would have established a regulatory process under the auspices of the State Bank Commissioner in the event an examination or report made to that commissioner determined the TEFI is critically undercapitalized or insolvent. It clarified provisions pertaining to the examination of an existing profitability exception pertaining to evaluations in a TEFI, and removed a provision that would have permitted the State Banking Board and Commissioner to examine any aspect of the fiduciary financial institution. It removed language that would have provided for the conversion of the Beneficient's conditional charter to a full charter, provide the pilot program would immediately cease, and allow the Banking Board to approve new TEFI charters. So those were some of the more substantive amendments that were made. The final bill to summarize before the House concurrent resolution were changes to the Captive Insurance Act, so changes in Chapter 40 related to the establishment of TEFI insurance companies. House Bill 2547 amended and enacted new law supplemental to the Captive Insurance Act to allow a technology-enabled fiduciary financial institution insurance company to operate as an authorized captive insurance company in Kansas. And as you may recall, the captive serves the function of a form of self-insurance. In this arrangement, the insurer is either owned wholly by the insured. The captive typically tries to meet a unique risk management need of the owner or its members. In this case, a pure captive is generally any company that insures the risk of its parents and its affiliated companies. The TEFI insurance company under this new law is a pure captive, and it is required to have common ownership and own at least 5% of the equity interest of a TEFI. The bill's proponent, Beneficient, noted that under this framework established in the bill, the TEFI could choose to secure coverage for events, including breach of representation or warranties made by an investor in connection with a transfer of alternative assets, credit risk associated with the financing of those assets, and risk associated with the management of alternative assets in trust. And you'll see the requirements there beginning on page 6 relative to the certificate of authority that would be issued by the Commissioner of Insurance for the TEFI insurance company. You would also see on page 7 some of those requirements placed on, for place of business, the board of directors and residency requirements, service contracts and examinations. Among those requirements is are related to the location of a principal place of business and the membership of the board of directors of that TEFI. And the principal place of business may be located in the same or shared office premises with its affiliated TEFI or another TEFI insurance company. On page 8, you'll see a few more of those requirements regarding the personnel who perform TEFI insurance company services and requirements on contracts and employment. The feature of the TEFI insurance company that the committees both spent the most time with is the next item, and those are payment in kind policies and in kind assets. And so a TEFI insurance company would be required to satisfy claims under a payment in kind policy by delivering to its qualified policyholder in kind assets or in a combination of in kind assets pursuant to the schedules attached to the policy, and the bill provides for the type of in-kind assets and combination of those assets. And those are further defined on page 10 of the memo and 11, and you'll see what some of those, what meets the criteria for an in-kind asset or how the policy, the payment in-kind policy would work. The bill also provides provisions governing examination requirements and for the organization of the TEFI insurance company under the Captive Insurance Act and other Kansas law and form selection. You'll see those provisions on page 9. The bill also created some requirements in the TEFI law regarding surety services and credit insurance, and it amended law to provide for the privacy of both the qualified policyholder and those who have established a FIDFIN trust or an alternative asset custody account in court proceedings. Those are further explained in section 3 of the bill on pages 12 and 13, and then naming requirements appear on page 13. There is also language regarding investment requirements and in-kind assets that appears in section 5 of the bill. The bill also had a mirror bill as introduced. That was Senate Bill 337. There were some amendments that were considered in the House committee that were largely clarifying, and this bill was effective upon its publication in the Kansas Register. And the final item summarized is relevant to ESG standards in House Concurrent Resolution 5034. And this was a resolution that would have provided several findings regarding ESG. And ESG, the way to look at it, it's a set of standards for a company's operations that socially conscious investors use to screen potential investments. The House Committee on Insurance and Pensions received an update from KPERS on this topic on March 7th, and the KPERS board has been monitoring this. And if you are attending tomorrow's Pensions, Investments, and Benefits Joint Committee meeting, this is a topic of discussion from the Chief Investment Officer and Executive Director Conroy. They will be reviewing some investment policy topics, and ESG will be included. So this is, the resolution was referred to the Committee on Fed and State Affairs, and it died in committee. And Mr. Chairman, that is a lengthy discussion reviewing the changes to the TEFI Act, new law regarding a TEFI insurance company, and the language endorsing this committee's position on issuance of a full charter retroactive to December 31st.
So thank you very much, committee. Are there any questions of Melissa? I see none. You must have been very, very thorough. We will now turn our attention to the State Banking Commissioner's Office for an update on FIDFIN institutions operations in the state of Kansas. Commissioner Herndon, I believe you're first. Welcome.
Thank you, Mr. Chairman. Members of the committee, my name is David Herndon. I am the Kansas Bank Commissioner. The agency that I lead is the Office of the State Bank Commissioner, also known as the OSBC. We are the sole financial regulator for technology-enabled fiduciary financial institutions, or TEFIs. OSBC received this designation by the creation of the TEFI Act, legislation adapted 2 years ago, or 2 sessions ago by the state of Kansas. I appear today to provide an update to the committee on the status from the perspective of the OSBC of the state's pilot program for TEFIs and the activities of the participant in that pilot, Beneficient Fiduciary Financial, or BFF. I am joined today by Deputy Commissioner Tim Kemp and OSBC General Counsel Brock Roller, both of whom will provide additional comments as well as answer questions along with me of any members. We did experience material delays in BFF's application submission. Most significant among those were the inability for BFF to provide us audited financial statements required as part of the application process, and our inability to obtain background checks conducted by the Federal Bureau of Investigation because of the way the TEFI Act is written. Both of these issues have previously been reported. The audited financial statements for the periods ending December 31, 2020, December 31, 2021, and March 31, 2022 have been delivered by BFF to OSBC. We received those on October 27, 2022. That resolved the application delay regarding financial statements. Regrettably, we have not made any headway with the FBI regarding background checks, so have relied on alternative checks. And we will request the legislature address this gap so that FBI background checks can be obtained on future TEFI applicants. At its November 21, 2022 regular meeting, the State Banking Board, which is the entity that acts on applications for activities by state-chartered banks, state-chartered trust companies, and state-chartered TEFIs, recognized that BFF's authority to transact business had been enacted by the Kansas legislature in essentially granting BFFs a charter to do business pursuant to KSA 92325D1. Consequently, the board has taken no additional action on BFF's application. But the OSBC and the State Banking Board both consider the BFF's application complete as required by KSA 92325A1. Other items recognized by the State Banking Board regarding BFF's state-granted charter include, one, the Banking Board's authority to approve or deny or take any other action on BIN's license pursuant to KSA 92302 was superseded by Beneficient satisfying all conditions of KSA 92325D1. Second, that Beneficient's charter was granted without review of the financial standing, general business experience, and character of Beneficient's organizers, or the character, qualification, and experience of its officers. And third, that the pilot program should be concluded and the Banking Board has the authority to approve or deny any subsequent TEFI charter applications that might be submitted. Notwithstanding the actions by BFF to complete the application process, the FIDFIN transactions that have been generated, the due diligence conducted by OSBC, and the recognitions by the State Banking Board, the concerns I have previously expressed regarding OSBC's ability to conduct meaningful examinations remain. In particular, the limitations in the TEFI Act that disallow consideration of safety and soundness principles generally established by international and industry standards, as well as the departures from generally accepted accounting principles, have and will hamper and even diminish OSBC's examination activities. Therefore, I once again request consideration by this committee and the Kansas legislature to allow us to conduct the type of examination similar or exactly the same as we do for other state-chartered banks and trust companies. Nevertheless, the OSBC has conducted 2 target examinations of BFF in 2022 and has scheduled a third that will commence later this month. The 2 targeted examinations were an Information Technology or an IT examination and a Bank Secrecy Act or a BSA exam. Both of those were completed this past summer and reports delivered to BFF. All examinations conducted by OSBC are confidential in nature between OSBC and the Board of Directors of the examined entity pursuant to KSA 403308, so particular findings cannot be disclosed. However, in Deputy Commissioner Kemp's comments, he will report on the findings and conclusions that may be disclosed outside of those confidentiality restrictions. The third examination, scheduled to commence December 19th, will target BFF's business operation as well as selected transactions from its book of business and determine a pass-fail result regarding BFF's compliance with the TEFI Act. Since the TEFI Act was written, or as it was written, precludes us from conducting a safety and soundness examination that meets our industry standards, a pass-fail examination determination finding is our alternative. As a result of the State Banking Board's recognition of the transactional authority granted BFF by the Kansas Legislature and the anticipated successful conclusion of the third examination, the OSBC and the State Banking Board would consider the provisions of the pilot program as satisfied, and the pilot program could be concluded. If in fact that is the case, other TEFI businesses would be permitted to apply for a charter in Kansas. I can report that as of today, no inquiries have been made to the OSBC from any other TEFI regarding potential applicants. There are some other influences and matters that we are monitoring regarding the business connections and interlocking management between BFF and a former affiliate known as GWG Holdings, Inc. OSB understands the business relationship between BFF and GWG was severed, but a bankruptcy filing by GWG and an ongoing Securities and Exchange Commission investigation regarding GWG's business activities are being followed by the OSBC and will be acted upon if BFF or any of its principals are adversely impacted. We respect that GWG is not our concern, it is not our applicant, but no representation or expression is expressed as to any involvement by BFF or its management in GWG's activities. With the chairman's permission, I'd now like to turn the podium over to Deputy Commissioner Tim Kemp to discuss the examinations that I referenced. Following Deputy Commissioner Kemp's comments, General Counsel Brock Roller would like to discuss and present potential legislative actions respectfully to be considered. But if there are any questions of me now, I'd be happy to stand for those.
Commissioner, thank you very much. Committee, I think we'll allow Tim and Brock to testify, and then maybe we'll have a question and answer session for all three of you, if that's okay.
Thank you.
Tim, welcome. If you could state your name and position for the record.
Yes, I'm Tim Kemp, Deputy Bank Commissioner for the OSBC. Mr. Chairman, members of the committee, I am pleased to report that the OSBC has completed 2 examinations for BFF to determine if industry standards and regulations have been met in the areas of BSA compliance and IT. Examination reports, materials, and ratings are confidential. However, without getting into specifics, I can state that BFF was well prepared for these examinations, and examiners found BFF to be in a position that did not cause any deep concerns in the areas of BSA and IT. The BSA examination was completed by TEFI examiners Aaron Emerson and Christy Umscheid. The IT examination was completed by TEFI examiners Michelle Kelly and Aaron Emerson. Examiners appreciated the prompt responses of BFF to requests for materials and data, which helped the examinations to be completed in a timely fashion. A third examination designed to determine compliance with the TEFI Act is scheduled to commence with an on-site visit to BFF's Heston office on December 19th. Certain materials have been requested and received from BFF for examiners to analyze and conduct off-site review. This is very helpful so that time spent on-site can be as productive and efficient as possible. A visit to the Beneficient Dallas, Texas office will likely occur in the early part of January, although not all details have been finalized. Due to the uniqueness of the TEFI business model and BFF being the first TEFI in existence, there is no anticipated completion date. There is no template for this type of examination, hence procedures to be utilized are being developed and may need adjusted at some point during the examination. Every effort will be made to complete the report of examination as soon as possible, while also ensuring that a comprehensive review is performed. Common practice is for de novo financial institutions to receive annual examinations for at least the first 3 years of operation. The OSBC, excuse me, the OSBC expects to treat a TEFI in a consistent manner with other financial institutions, and as such, annual examinations are anticipated for the initial 3 years of existence. Future examination schedules will be dependent on examination findings and the activity of BFF. To aid in the communication between the OSBC and BFF, it was mutually agreed upon that Deputy Commissioner Tim Kemp, myself, and Managing Director and co-head of Fiduciary Financial Institutions, Alan Dinas, would meet monthly in person to discuss current issues of concern, including the scheduling of examinations. The discussions have included items that have gone well and those items that have not gone as well. It is truly a discovery of what is needed to properly regulate a TEFI. These meetings have resulted in an improved dialogue between the parties and is seen as beneficial as we continue to develop standards and expectations from regulated entity and regulator. Thank you very much.
Thank you, Tim. Brock, if you could also state your name and position for the record.
Thank you, Mr. Chairman and members of the committee. My name is Brock Rayther. I'm General Counsel for Office of the State Bank Commissioner. I'm here today to discuss a proposed bill that we are requesting to amend 2 statutes in the TEFI Act. Specifically, this bill will amend 92301 and 92302. It is unfortunate that our agency is still unable to receive background checks on any TEFI officer, director, or organizer. We implemented all the changes requested by the Federal Bureau of Investigation when we implemented the 2021 House Bill 2489. As of today, we still are unable to receive background checks. We have received some additional requests to add to the TEFI Act in order to receive background checks. First, it was requested that we define officer, director, and organizer. So those definitions have been added to 92301. And second, we are requesting to amend 92302 to clarify that the commissioner has authority to require fingerprinting. This is a customary practice from the Office of the State Bank Commissioner's office to perform this on behalf of the State Banking Board. And second, as a condition to receive background checks from the FBI, we are required to agree not to accept any private entity criminal history checks. I am proposing some additional language that complies with this request, provided we are able to receive background checks from the FBI and KBI. We're also required to not disclose criminal history information for any other purpose, or to treat the background checks as confidential. So we have included provisions to address that. We do not view these last 2 issues as significant issues. And thank you.
Thank you, Brock. Committee, are there questions of the representatives?
Thank you, Mr. Chair. Commissioner Herndon referenced this in his testimony, but anybody can answer. Can you maybe briefly walk through the difference between if we had not removed the safety and soundness language in 2489 versus what you had to do since we did remove it?
Traditional safety and soundness examinations do not consider intangibles as part of equity, and the TEFI Act does. The TEFI Act also does not consider earnings as a component for the examination. Traditional safety and soundness examinations do. So we recognize the other instances of components in an examination that may or may not apply because the TEFI does not accept deposits. So there's no issue in those regards, but primarily those two major issues, the definition of capital and the inability to consider earnings in an examination report.
Senator Pittman.
Thank you, Commissioner. And first, I want to thank you for your work. Obviously, this committee, or the committees that in the legislature, has put you into a position that is kind of new. We have to recognize that, as we look at these new forms of investments and look at our legal and regulatory definitions and frameworks that, this type of thing hadn't been contemplated before for now. And so you're taking this on. We rely on you as a legislature to put your experienced eyes and your people's experienced eye. And so we appreciate your advisory capacity here. Because we, obviously a lot of us aren't as deep financially as you are. So thank you for that.
Thank you.
With that in mind, what would be the impact of allowing those two definitions, allowing, for example, earnings and the other piece? What do you think? What do you anticipate that will help? How does that help us in terms of evaluating the TEFIs in your perspective?
From a safety and soundness perspective, both are critically important in my opinion. Capital is the ability for a company to continue or operate, and it's implemented by a firm's earnings. Obviously, if earnings are not present, capital is eroded, and regarding the ability for the owners or principals to provide additional capital is unknown. So those two components are, as I said earlier, critical in determining they're two of the 6 components that we typically would take a look at in a safety and soundness examination. Not being able to consider either of those severely restricts our ability to determine the viability and the safety and soundness of the regulated entity.
If we were to project out into the future and this one of the TEFIs, this TEFI or another one were to go public and those earnings and such things were just, available to your common investor, do you think that would be enough of a, I don't know, would that change your opinion about?
I'm not certain that it would, with respect of the differences between an investor making a decision should they invest and a regulator making the decision as to safety and soundness. I think they're independent.
Thank you. Thank you so much.
Representative Kelly.
Thank you, Mr. Chairman. Commissioner, this may be a question for you or for Deputy Commissioner Kemp, but when you go in, you've received, now you noted in your testimony, the financial statements that you need to go into the next phase. Will that be enough to provide any of the, I guess what you would say in banks, the comfort of knowing that the bank commissioner's office, the examiners have looked at the bank? Is that, you're still missing, I know the earnings piece and you're missing some of the others, but does that give you enough to go on to make any kind of determination at all?
Somewhat, but not, in my opinion, total. If I may clarify, yes, we will take a look and we will do an analysis of the financial statements, but we can't consider that analysis in assigning a rating or a satisfactory, anything more than a pass-fail examination, because of the Act does not allow us to consider or requires us to consider intangibles as a form of capital. That's a departure from generally accepted accounting principles, but since it cannot be part of our determination, we can look at the financial statements to determine viability and to that sort of thing, but we cannot express an opinion as to the overall examination findings.
So in some searching I did, I came across the bankruptcy filing of GWG, and it did include some financial information for Beneficient in there. And this is just a question. The goodwill made up 75% of the total assets. I don't know that I've ever seen anything close to that high in my years. Is that unusual?
Again, we don't have any other TEFI to compare it with, so I can't speak to that. But in my experience as a banker and my experience as a bank regulator, it is significant and in perhaps alarmingly high when determining the components of traditional capital.
I mean, I work for a conservative bank, but it would be, I don't know that I've ever seen it out of the 20s.
A bank balance sheet would not contain goodwill or other intangibles as equity.
Would it be?
It would be perhaps an asset, but not equity.
Okay, thank you.
Representative Osman.
Thank you, Mr. Chairman. Thank you, Commissioner, for your testimony. Part of your testimony included FBI background checks. And you had mentioned that you, because of your inability to secure background checks in a timely fashion, you were using alternate methods for background checks. Can you walk me through what those alternate methods are and what the disparity is between that and what you would be able to get with an FBI background check?
The FBI background check would include any criminal activities. The background checks that we've been able to conduct are basically civil record kind of checks that may or may not include any criminal activity charges or that sort of thing. So that's the primary difference, is a search of public records for instances of any filings by the principals or that sort of thing. I'm not an expert by any means on the scope of an FBI background check, so I really can't compare or contrast between a third-party private company that does those checks versus the FBI.
I see no further questions. Thank you, Commissioner Herndon. We will now turn our attention to testimony from our representatives from the Beneficient Company Group. We will start off with former Senator Jeff King.
Would also like to introduce, we have following me speaking, Derek Fletcher, who is the President and Chief Fiduciary Officer of BFF, Alan Dinas, the Managing Director and Co-Head of Fiduciary Financial Institutions, and Brad Hepner, the CEO and Chairman of the Board of BFF, will follow me. Mr. Chairman, a 30-second aside, if I may. About 12 years ago, almost to the day, I got a call from a local banker in Independence who had one question for me. He said, Jeff, how do you think I'd do serving in the Kansas House? And Chairman Kelly, I think 12 years later, I know this is the next to last committee meeting you'll have in the House. I think the answer is pretty clear, and that is you were an extraordinary one. And it was an honor to get to vote for you, an honor to watch you fill the seat so admirably well that I held previously myself, and an honor to consider you a mentor and friend. So I would personally like to thank you for the work you've done for Independence, for Montgomery County, and for the whole state. And thank you, Mr. Chairman, for allowing me that aside. A little bit more recent history than that. March 10th of last year, Beneficient, Brad and Derek and others through this chamber introduced Senate Bill 288. And in just over 20 months, I think truly extraordinary things have happened with TEFIs in Kansas. When Brad and Derek first came to the legislature, they made 3 goals and promises that they hope to be able to keep. One was, through the TEFI legislation, to be able to create a world-class technology platform for alternative asset liquidity, something that was unique not just in the US, but in the entire world. They had a goal by the end of 2022 to have $250 million invested in TEFIs in the state of Kansas. And through that, to have $10 to $15 million generated for rural economic development through economic growth zones and through money directly given to commerce. I'm happy to report here 20 months later that all of those promises have been met and exceeded. You heard a little bit from OSBC of the examination that they did on Ben's technology platform. In addition, Derek will talk later about 2 other examinations and reports that were done on the technology. And those 2 that aren't confidential, I think, show the world-class nature, the sophistication of the technology that Ben is bringing to bear with its TEFI. The $250 million goal for investments in 2022 through the end of the 3rd quarter this year has already been exceeded. We're at $255 million and growing. As well, the $10 to $15 million goal for investments have now already exceeded $18 million invested in rural Kansas through economic growth zones and through commerce. And lastly, I know the vision that Brad and Derek articulated 20 months ago talked about this being the starting point of Ben being the first of numerous TEFIs that hopefully would come and create an industry based in where Kansas is a global leader. And Derek will talk a little bit about, I know I've had conversations, he's had conversations with interested parties about some very exciting interest that Ben has seen from others that we hope as we move beyond the pilot phase will show the future growth for all of Kansas that new entrants into the TEFI market will bring. And with that, I'd like to turn it over to Derek Fletcher.
Hello, Mr. Chairman. Members of the committee, my name is Derek Fletcher. I'm the President and Chief Fiduciary Officer for Beneficient. Before I start my comments, I would like to introduce a couple of other representatives from Ben that are here today. First, Emily Bowersock-Hill. Emily is our Kansas Director. She's a member of our Audit Committee, and you may know her in terms of her role as Chair of the Investment Committee for CAPERS. We have Keith Martins, who is also a co-head of our fiduciary financial institutions in Heston, as well as Greg Woodyard. Greg runs the kind of TEFI accounting for our office as well. As Jeff mentioned, we were really pleased that when we were here a little over a year ago, we made promises in terms of the business that we would be able to generate and the benefits to the economic growth zones that we could deliver, and are pleased that we have fulfilled those promises as Jeff mentioned. What I would like to do is talk about one other accomplishment that we're very proud of, and then move on to the economic growth zones and give you an update of where we are in that program. With respect to our technology platform, as you all know, technology enablement is a fundamental element of the TEFI Act. And it is more than a website. It is more than internet capability. It is a robust online transaction processing system where a customer can engage with us online. They can transact business. They can elect the form of liquidity they would like to receive and close that transaction through that online customer portal. Now, if you go onto our website, you're not going to see that. Right? It's like going to the Bank of America website. You would see Bank of America, but you're not going to understand the power of their online banking system unless you have login credentials. And so for our customers, they're granted those credentials and they can transact. We understand, as all of us do, when you interface with a financial institution, one of your primary factors of consideration is, I want to make sure my personal information is private and it's secure. Our customers are no different, and we have gone through great effort to make sure that we have a technology platform that meets or exceeds industry standards. And so in addition to the OSBC examination that Deputy Commissioner Kemp discussed and Alan Dinas will review in a moment, we've also had 2 really important achievements on our technology this last year. First is AT&T net bond certification. What is that? So AT&T sends experts, they interview our personnel, they review our policies and procedures, and most importantly, they test the integrity and security of our system. We had very favorable results that have resulted in certification by AT&T that you can, when you log onto our website, you can see that certification. Second, our auditor has also examined our technology platform. They have issued what's called a SOC 2 Type 1 report that basically says that our technology platform is constructed in accordance with high industry standards. We expect that by June of next year, we will have a SOC 2 Type 2 and a SOC 3 report that would indicate not only is the technology structured according to those high industry standards, but it operates over time consistent with those standards. Upon receiving those certifications, we would be the only firm in our industry that we're aware of that has all three of those reports. And so I wanted just to highlight that because technology is such an important aspect of the bill and the operations of TEFI, and to provide this committee with assurance that we take that seriously and that we believe we have constructed really an innovative world-class type system and with third-party verification of those facts. Now, I'd like to move on to the fun stuff, which is the economic growth zones. And as Jeff mentioned, through the FidFin transactions that have been closed through September 30 of this year, we have delivered a little over $18 million of value to the economic growth zone program. 2.9 of that has been allocated to the Department of Commerce for the TEFI Expansion and Development Fund, and I'm really excited to hear from Mrs. Willis later this morning to report on what Commerce has done, the program that they have implemented, which is really exciting for rural Kansas. But on the economic growth zone side, and that really being for our company, Harvey County and Heston in particular, you will note that there's been over $16 million delivered to that foundation. That foundation is comprised of 13 board members, 9 of whom are community leaders, the mayor, city administrator, president of the local college, superintendent of schools, et cetera. And 4 are BEN representatives. What I would like to do is, with this one slide, just give you a picture of how the program is currently structured, just so that you have an understanding. Because this will also help with materials that you have in your folders today, and that is audited financial statements for each of these entities that are involved in the Economic Growth Zone program. We know this program is important. We know it's important to this committee. We know it's important to the state at large. And we know that those that aren't as familiar with the program have had questions in the past of, have the assets been delivered? Are they there? Has funding occurred? And so we wanted to go to the effort of having an independent audit conducted to provide this committee and others with assurance that that funding has in fact taken place. So the first component, if we could go back to that prior slide, the first component of this system is what is called the Kansas TEFI Economic Growth Trust. This receives the 2.5% from the customer when a transaction is closed. Now, why do we have this trust? And I'll give credit to Bob North over at the Department of Commerce, because this kind of came into being when we first discussed this program. As you know, the TEFI Act has a structure that provides how the economic growth zone contributions are allocated between Commerce and the economic growth zones themselves. So if you think about a customer that comes into our system, customer A and customer B, well, their transactions could differ in terms of the allocation depending on where we are in that waterfall structure in the statute. So what this trust enables the customer to do is have their transaction be very clean. They designate the trust as the recipient. The trust then divides those assets according to the statute among Commerce and the economic growth zone, which in this case is the Heartland Foundation. The last thing that I will mention in this regard is you will see up at the trust level, of that 18 million, we still have 1.6 at the trust. And you may ask yourself, well, why hasn't that moved? And the reason is an important one, and that is excess funding. So I want the committee to be aware of the fact that the TEFI Act requires the 2.5% of financings. We have structured our transaction to actually provide more than that minimum required amount. And so this is an additional 1.6 above what the TEFI Act requires. It sits in the trust. It's allocated exclusively for the benefit of economic growth zones. It will likely move down to the foundation to support the grocery store initiative that we are excited about and that Brad Hepner will speak to in a moment. But for right now, it's sitting at the trust level. It could be allocated to colleges and universities here in the state. It could be allocated to other initiatives within economic growth zones, but it is dedicated to those purposes and just waiting for distribution. So with that, there are some other slides that in the interest of time, I won't cover. They just provide you with additional information about each of these vehicles. And again, in your materials, you have the audited financial statements. You have a schedule that depicts how these benefits have been allocated between Commerce, and it follows the TEFI Act. We met with Commerce this morning. We'll be working together to make sure this is a type of report that is helpful to them. And again, we would envision that each year as we appear before this committee, we would be providing similar materials for your review. So with that, Mr. Chairman, I'll ask Alan Dinas to present.
Thank you, Derek.
Yes, sir.
Alan?
I think I said almost too long. So I'm Alan Dinas. I'm one of the managing directors of fiduciary services for Fiduciary Financial. Live in Hayes and work around the state spreading the good word about BFF. I wanted to talk a little bit about what's happened this year to give you an idea of what's been going on. We did indeed deliver the financials I've got October 26th, and we delivered them in spades. In addition to a financial report on just our holding company, which was originally asked for, we provided statements for BFF as of 12/31 and 3/31 of 22. We discussed and provided reports to show a breakdown between GAAP and non-GAAP accounting to help the OSBC understand what's going on. It's very complicated, and it helps to have that roadmap. We also provided audited financial statements for 19, 20, 21, and 22 for our holding company, which is what really probably exceeded the request. And then I can tell you that we've got audited financial statements now as of June 30 and 9/30, and we'll be uploading those to the OSBC hopefully yet this week. So they've just been issued. If we could skip to the next slide, give you a little bit of a time frame. We talked about these exams. I thought you might find it interesting on just how this process works. On the IT exam, we received a data request from the OSBC on April 25th. And that's normal. That's in the banking world. You get about a 30-day notice along with a list of documents that they want. We commenced the exam on May 31st, completed it on June 27th, about a month later, and I can tell you that the result was successful. Then we started the BSA AML exam. And data request on that came in August 25th. September 26th, the exam was commenced, completed again roughly a month later. And then we had a good result there as well. So finally, the exam at hand, if we could skip to the next slide. I think you can see that this one is the miscellaneous part of the exam. It's not targeted. It's going to cover quite a few issues with a lot of moving parts, and we expect it will be complicated and will take some time. We got started on October 18th with the first document request. Then on the 16th, we received another one. And then on the 17th, still a third one. And as examiners are starting to work through these documents, they're figuring out the chain, and so they're asking for additional information, and we're working to comply with that as soon as we can. We expect the exam to commence on site in Heston on the 19th, and then tentatively July or January 3rd, we're thinking we will get started down in Dallas. I think that's a little bit tentative, but we've talked with Tim and I about who's going to be on vacation and who's not, and making that work. So this part of the compliance exam is going to cover quite a few topics. It'll be more bank-like in nature. I can tell you that right now we're getting a pretty standard trust questionnaire in terms of what's being asked. And as I talk to the examiners about what they have in mind in terms of what I didn't see in the request, they're still working on that. So we do not have a problem with the extent of the requests. We're wanting them to look at us as thoroughly and deeply as possible. We view this as an opportunity for us to really help them understand the industry and give us an idea about regulatory expectations as we work along. I would say that everything is going pretty well. We're working good lines of communication. Might point out too that in the course of the document requests here, the OSBC does see our earnings. They've seen our audited financial statements, and right now is wherever they want to look, whatever they want to look at, we're letting them do that. We think as we get into these capital issues and some of the other things down the road, it's important that the examiners have had a long, deep look at our organization. So when we sit down and work on specifics, we can have things that work well for the industry. So finally, the last slide on mine is we don't have any serious legislative proposals for this session. What we would like to do is expand the definition of the kinds of entities that we can make contributions to. It'd be item II at the bottom. As we work with economic development and charitable giving in the state, we discover new things every day, and this is just something that will make it work, and make it work for smaller communities as well. So with that being said, I will turn the podium over to Brad. He gets the fun stuff. Thank you.
Thank you, Alan. Welcome, Brad.
Thank you, Chairman Longbine. Appreciate this. And Vice Chairman Kelly, appreciate your service to the state and having us here today. I also want to acknowledge one of our famous directors, which is Emily, who's here, lives in Lawrence, and she's been an incredible asset to the board of directors. She and I are the two Kansans on the board and make sure that we're going to make Kansas proud. That's our job. I want to first start by addressing a couple of the questions that were asked by the committee, specifically from Representative Hsu and Representative Kelly, and the responses from the bank commissioner. I would like to remind everybody back to the time of the committee hearings on why do we have intangibles in the law? Why is that there? That's the first question on safety and soundness that the commissioner raised. Why is it there? And the second question is, why do we not look at earnings the way that you normally would for a typical bank? So let's start with the first question. And the first question is really answered in the title of the law, technology enabled. A company like ours is required to value its intangibles. We had to do that. That's that online platform. It's not a website. It's not something anybody can log on to. Before you can get into our online portal, you have to go through KYC, just like at Representative Kelly's bank. When you set up an online banking account, there's a KYC process that has to happen. We need to know who you are. We need to make sure you are who you are. We need to make sure you're not Osama bin Laden. We need to make sure you're not some crooked person and so forth. And we need to follow BSA, AML, OFAC, and then you get permission to transact and have a bank custody account on our online platform, just like what you do on a mobile phone. We have to value that. That's an intangible. And Commissioner Herndon made the comment that it's the assets you look at for safety and soundness, the assets and the capital that you need to operate. The capital that is represented by the value of that platform, we must have to operate. Without the technology enablement, we have no TEFI. It has to be valued, has to be on the balance sheet. If that got shut down, we're shut down. There are no economic growth zones. I'll put it in a little simpler term. If we shut off Vice Chairman Kelly's online banking platform and ATMs, those are intangibles. That money is moving through the air in digits. If we shut them off, the FDIC would be receiving his bank within 3 to 6 months. It'd go broke. They're not required to evaluate those intangibles. But what Wall Street is doing now, led by our lead banking institutions that keep us afloat, like Jamie Dimon at JP Morgan, they're directing regulators and everyone to say, we have to look at intangibles. We have to consider that we are an intangible business. And without those intangibles being valued, we could go broke. We could go broke. Without my ATM operating out there to take deposits and distribute cash through the technology that allows it to do it. Without the online banking through my cell phone to be able to set it up, we're going to go broke. That's why we wrote the law the way we wrote. And we have to have that on our balance sheet. It's a very fundamentally important asset. I'll close on that discussion that each one of you probably have a retirement account, 401k, you probably have a mutual fund that invests in the NASDAQ. When you invest $100 in a NASDAQ index fund, how much of that money is going into intangible value of the companies inside that NASDAQ fund? How much of that value? $92. Only $8 is intangible. Only $8. Our global economy, the U.S. economy, the banking economy has changed in 15 years. It's intangible. In 15 years, it's intangible. That's what it is. And so our laws have to move it forward. And that's what TEFI is doing. And it's doing it in a very safe, secure, and sound way. Why is that? We don't accept deposits. We're not putting anybody's capital at risk. We don't require the state to invest anything. We're not putting any taxpayer dollars at risk. We're not doing that. But we have got to value that, and we have got to consider that big goodwill intangible amount. Our goodwill is our intangible system. That's what that is on that balance sheet. And that number will come down as we do and grow and do more business. It will come down because it is a set number that does not get adjusted upward. It is a flat number that won't go up. But every TEFI is going to have an intangible at some point, and we're going to have to get used to that. And that's why that adjustment was made in the law. Now, when we turn to the earnings side and the question about earnings, on the earnings side, TEFIs, again, they're fiduciaries of trusts and fiduciaries of the beneficiaries of the trusts. What we learned in the last 7 years of creating our business is we have to consolidate those trusts. We have to consolidate our customers' assets onto our books under GAAP rules, under PCAOB rules. It's very weird. It's very odd. And in fact, we went to the SEC through our former parent and said, this is just really odd. And they said, that's the way you're going to do it. We have to consolidate. So it's the same as Representative Kelly. If one of your borrowers, a farmer, came and borrowed money from you, came and borrowed it from us, we have to put his farm on our books and records and report it that way, even though we're just lending him money. If you're lending him money, do you put his farm on his books? No. You don't put his house and buildings and tractors and everything on the books. That doesn't happen. But under PCAOB and GAAP rules, we have to, because we're the fiduciary over those assets, and that's a requirement we went through. As a result, those earnings from that farm go through our financial statements, and they look like this. And so you have to extract that and look at what is our real earnings. Well, those revenues and those earnings, they're not GAAP. They're not going to show up on a GAAP financial statement. That's why we provide the commissioner and his staff with non-GAAP statement. We say, test us on this. Here's the GAAP, and here's the reconciliation that takes the two in between. because we're not in charge of that farm. But because we're a fiduciary over it, we have to consolidate it. And those revenues and those expenses and all those items are going through our GAAP financial statements. I wanted to provide that as background to continuously remind this joint committee that's why the law is written the way it is. And we're taking step forward in Kansas to advance an industry, but we're doing it in a safe and sound way that without depositors, without FDIC insurance, without taxpayer dollars at risk, with no money having to be invested by the state residents, we're doing it the right way. And so we're going to have to get regulators, we're going to have to get commissioners to understand the points that I'm making and hopefully embrace it, because the net economic result of what I'm going to talk about next is what's really exciting for the state, the economic growth contributions and the development that we can do through the Department of Commerce by opening this out nationally. I do want to clarify one point made on Alan's last presentation in the materials. We do our audits once a year. Our fiscal year is March 31 now. We changed it from 12/31 to March 31. The June 30 and the 9/30 numbers are reviewed by our auditors. They're not audited. So that's a mistake in your material and in the information that's being provided to the bank commissioner. The exciting point now, if we can go to the next page, I get to announce the City of Heston announced, along with the Beneficient Heartland Foundation, the first deployment of its funds. Our town's last grocery store closed now 5 years ago. Our main street is left with a hardware store and a variety shop, a women's variety shop. And it has about 22 buildings on our main street, and 2 of them have those stores in it. The rest are either boarded up or are church offices that people come and go once every 2 weeks from. With the economic growth funds that are now in the foundation, we've worked with the city, and we are taking 90% of one side of our main street, and the shop owners that own the closed businesses there, church office and everything, are in the process of committing into a brand new 18,000 square foot grocery store. It'll be a little more than that. It'll actually be, that's a main floor. The front of the grocery store is going to look like 10 buildings that used to be there, that were built from 1888 until our Great Fire of 1920. Those are the buildings, including our 1886 railroad station. Now, what's misleading about that is that's all one store. So when you walk in, it is a well-lit store, which will be run by Pat and Jordan White from Lyons, Kansas. They operate about 6 stores. They're a 3rd-generation Kansas family grocery store operators. Be a full-service grocery store and will serve as an anchor to our Main Street. As a result of that anchor on Main Street, we already have 3 other businesses that are wanting to come back to Main Street. And so if Beneficient takes off the way that we're hoping it takes off, and we have additional capital inflows, both the Department of Commerce is going to benefit from that with the grants that they're making statewide to rural communities, and our hometown will be able to help facilitate other businesses to be able to reopen and conduct business on Main Street. So we're very excited about that. That project like this and what other TEFIs can do represents the public convenience and advantage that we expect and require of state-run banks and trust companies. And this is a very good example. This was announced at the Heston City Council meeting the first week of November. Newspaper ran a lot of good articles on it. The foundation and the trust are funded. I'm hopeful that it will be enough funding to provide for what you're looking at there. The funding in there is nearly 3 times the amount that the White's family spends on other of their grocery stores, because we're going to have a little cooking classes area and other things to encourage tourism into the town from the surrounding community. So there's going to be a variety of other features that we're spending funds to help it really thrive. I'll go to the next topic I've been asked to cover, and that's Beneficient going public. Some may be aware that we announced here about 2 months ago. CNBC picked it up. Most all of the public press picked it up. Kramer, if anybody watches Kramer on CNBC, he picked it up. We announced that we are merging into a special purpose acquisition company. That's a vehicle that has capital in it. Typically, when you do that, you then go raise what's called a PIPE. We have pre-raised our PIPE, and it is funded in. And so we're completed with that process. Beneficient has met all of its closing requirements, and we are within a couple of weeks of filing with Securities and Exchange Commission the necessary paperwork to begin the work with them at preparing ourselves to list, most likely on the NASDAQ, currently on the capital markets, and then we'll within a couple of months move to the global select market, which is where Google and Apple and everyone trades there. What's the importance of being able to go public? The first important piece for us is that it fuels our balance sheet, just like you have across First Bank, one of the state's probably biggest bank. Is it the biggest bank? Interest, but the state bank, biggest state bank charter. They're public. That fuels the balance sheet and helps them continue to be able to grow. We need to fuel our balance sheet. We need to do that through the U.S. capital markets. To do that through the U.S. capital markets, we need to be a public company. So we've made the announcement. We're going to go through the very arduous and long process of getting there. I believe that our NASDAQ analyst meetings in New York are scheduled to be for the second week of January, in which we'll get our announcement and debut out there. The listing probably we should expect in the mid to end second quarter, when we'll actually be publicly traded. And that extra capital then will fuel our balance sheet to be able to do additional FIDFIN transactions. Additional FIDFIN transactions lead to a 2.5% fee to the state, which funds the Department of Commerce for statewide grants and which funds the local area economic development zones. That is, that's a little bit of an update on our go public and some answers to the previous questions. I would like to dream, like I've done in all the other ones, a little bit. We met our first year goals. This is 5-year, this is 10-year goals. I always in the testimonies would talk about South Dakota making a mark in credit card trust banking. They have 25%, almost 25% of the national market for credit card trust banking. Utah has 94% of the national market for industrial loan banking, run by regulators who are innovators, who have created these laws that just don't make sense when it comes to community banking, but it created them. And the state of South Dakota has 900,000 population and is making a lot of good fee income off of that. If we think about our industry, the little subsegment of the industry that we work in at Beneficient right now is about a $200 billion a year industry. It's $150 billion for big institutions, done by big institutional, non-fiduciary financial institution companies, and $50 billion that you need to be a fiduciary financial institution to attack. And that's $200 billion a year industry. At a 2.5% fee on that $200 billion industry, you're, of course, right at about, in that neighborhood, about what, $1.5 billion, $1.25 billion or so that you're generating, $1.25 billion or something like that you're generating. That $1.25 billion, I believe, approximates about 5% of the state expenditure budget. That'd be an annual amount if we got 24% of our small sector of the industry. Our small sector of the industry is $200 billion. That's our small sector, okay? It's a much bigger industry. It's a $10 trillion global industry. But our small sector is $200 billion. If we got the credit card market share that South Dakota has, that's 25%. That leads to $1.25 billion a year in TEFI fees coming in, about 5% of what the state spends. But now let's dream beyond that, because the way in which the law is written is to attract not only our small industry, but to also provide a home for the big industry, the $10 trillion industry. So if we went to that $10 trillion industry and said, we just want 1.5% of that industry, that's all we want, 1.5%. We want about 30 to 50 firms to come here. 30 firms would be about 10% of all the banks we have. We have about 300 state banks, about 20% of the banks. So if we just created a little cottage industry like that, that's an additional $3 billion a year in TEFI fees off the transactions and the volume that they would do. Just 1.5% of that big industry, with our 25% of our main industry. This is something I really believe we can do in 5 to 10 years if we properly operate this. You add that together, that's $4 to $5 billion. What's that pay for? All of our state education. It's what the state's spending on the state education. That's the opportunity we have in front of us. I know that the regulators have said no one else has expressed any interest. There's reasons for that, because it hasn't been very welcoming on the, on the rollout of Beneficient and so forth. We've gotten a lot of interest. And we've included in your packet of information a letter from a Wall Street-based, Boston-based firm. Their main headquarters is in Boston, run by former senior leaders of some of the largest financial institutions in the world who have studied the law and who engage now and want to go out as a practice of their business and go across Wall Street, go across the Boston Financial District, and start to roll this out to other firms like Beneficient and explain the benefit of coming to Kansas. They've authored a letter to tell you, we love what we read, we love what we see, and as soon as you're done with your pilot, they would like to take it upon themselves as an advisory, capital advisory agency of former executives to go out and begin to roll this out. I'm very welcoming of that, and to get them busy at starting to bring others into the state. We need to be prepared for it, because when our competition comes in, they're going to want to be able to move along. But that's our march toward trying to get 25% of our small segment of our industry, or 1.5% of the big segment of the industry. And it can lead to a tremendous opportunity for the state. I like, when I was back home and we were talking about this a few weeks back, I have a crusty old cousin who's, it was our great-grandfather who really got the farms going. And what got us going in ag and wheat here was turkey red wheat that the Workingtons brought here from Ukraine, from Prussia and Ukraine back in the 1870s. And he said, this is just like bringing turkey red wheat to Kansas. That's still the grain, that we seed and we harvest. And so I kind of like to taking it back to the 1870s during that period of time. We're bringing something new to Kansas that can really lead to something beneficial, and we're talking 30 to 50 companies that we would need to try to regulate in that process. So I'll close with that dream, overall dream, and ask if there's questions.
Thank you very much. Committee, are there questions of anyone with the Beneficient Group?
Thank you, Mr. Chair. I believe it was Alan who proposed the change in the statute slightly of including the nonprofit corporations in it.
Well, let's have Derek answer, because I think he probably knows the answer.
Or whoever, yeah. Can you just discuss that a little bit more? Maybe as Derek, sorry.
The nonprofit corporation inclusion.
Because there is a difference between a charity and a nonprofit corporation, correct?
Yes, Representative Hsu. The main difference between them is the federal tax exemption. And so what we have found in working through the Economic Growth Zone program is there are a number of charitable organizations that have not secured and don't intend to secure federal tax exemptions for contributions made to the organization. They still operate as a nonprofit, they still operate as a charity. It's just that if you were to make a contribution to them, you would not be entitled to a federal income tax deduction for that donation. And so for Beneficient, for us, when our customers make those contributions, our customers don't claim an income tax deduction for those contributions. Beneficient doesn't claim a deduction for those contributions. And so what we have found is there is a subset of charitable organizations that operate, that do good work in communities. They don't have a federal tax exemption, but that does not preclude them from operating in a charitable fashion. And so our purpose in adding that language is, why not be as inclusive of all charitable organizations that are operating regardless of their federal tax exemption?
I may follow up.
Yes, sir.
If I understand it right, a charitable organization is a subset of nonprofit corporation. So would you guys oppose just changing nonprofit corporations to a charitable organization in that case then? And then just ignore the federal internal deduction part?
No, that we would not object to that. It's really the limitation of the federal tax deduction that was the problem. So if we strip that out and just said charitable organizations, you know, we had proposed Kansas Nonprofit Corporation with the idea being if we have an organization that is not, you know, I guess capable of recognizing the deductions for contributions, would we want those to be in Kansas so that rather than having, you know, a Florida or a Texas nonprofit that was operating in Kansas, would we want Kansas to have oversight in terms of the Secretary of State? And so would we want that kind of formation to be in Kansas? But in answer to your question from our perspective, no, I think it's just the removal of the federal tax status of that organization is the only barrier that we see.
Committee, additional questions? Senator Fagg?
Thank you, Mr. Chairman. Derek, could you, as far as your board members, you still have those two Federal Reserve former chairmen on there? Could you kind of talk about that a little bit? I understand they're still there. I just want to confirm that. So.
Absolutely, yeah. Brad, do you want to speak to that?
Sure. Both of them serve on the credit committee. So they make the determinations of what assets we finance and don't finance, or the guidelines and so forth. And I believe both are on the Enterprise Risk Committee. That's a fairly large committee. So the rate hike, I like to tell a lot of stories because one is a little more on the side of the Hawks and the other one is a little on the other side. And so we have very healthy and fun discussions at our board meetings and especially at the credit committee meetings. But the current rate hikes, at every board meeting, we make them put in a prediction in an envelope, each of them, okay, and sit back. These rate hikes were predicted by both of them. One predicted them to come, all of them have been more predicted, and all of them were predicted to have come about 6 months to 9 months earlier than they did. And so both of them did not predict the delay in them coming. I will say that the rapid nature of them, one after another, wasn't predicted. It was expected to begin quicker, and I mean earlier, and then a little delay and a little delay and so forth. Instead, it stalled and came quickly. So those are the kind of discussions that we have at the board meeting on the global economy, because that has macro influence on our pricing for the transactions we do at Beneficient Fiduciary Financial.
Brad, could you kind of give us the name and what areas they were from?
Certainly. Richard Fisher was the CEO of the Dallas Fed for a number of years. You'll see you'll see both of them. And then Dennis Lockhart was the CEO and head of the Atlanta Fed. And then under Bernanke, they were brought on to the Open Markets Policy Committee to guide us through the Great Recession in 2008 and 2009. They were two of the three most vocal restructuring agents for the Federal Reserve under Bernanke during the great restructuring time. Both of them have banking backgrounds, and I do like to always pause and talk a little bit. Everybody knows Richard Fisher because he's on TV about once a week on CNBC explaining the Fed's moves and so forth. Dennis is on probably once a quarter. But Dennis was part of Citigroup that went to see the governor in South Dakota in 79 or 1980. Yeah, early 1980 to get the credit card trust banking laws put in place. So Dennis had a deep conviction and belief in what we were doing here because, as everyone knows, we cut and paste from South Dakota's laws a lot of their specific provisions and put them into the TEFI Act when we were working with the capital lawyers and so forth. So Dennis has kind of a foot in what we're doing here. Emily's here too. You might comment there. They're always lively.
They're very lively, and I keep watching the markets, and it's fun getting to be.
Senator Pittman.
Thank you, Brad, for being here. And thank you, Mr. Chairman. I was just wondering, so we're going to go presumably go public, and congratulations on that if it happens. We're going to get an infusion of capital into the Beneficient, one of the organizations there. You know, Representative Kelly had mentioned the role of capital in the banking commissioner's evaluation, and then there was a debate about whether one should include that. The response is, of course, that we have transactions going on, right? Transactions happening, so there's not as much need to have capitalization. So with that in mind, 2 points. I mean, do you think having more capital inside of the business actually provides, I mean, what we're trying to do is trying to protect consumers and investors, obviously, safeguard the financial systems, but allow for your innovation and competition that you've laid out a nice vision for. With that in mind, if we have more capital, let's say we were to go forward with some kind of other provision where we had more capital required, does that provide more, in your estimation, more protection for anybody other than the firm itself? In other words, there's, from a transactional and liquidity standpoint, it sounds like the investors don't have as much exposure as they might in other industries. Is that a fair evaluation, or am I?
That is, and you know, here's what we're trying to compare apples and oranges, because we don't have depositors. So more capital would provide a greater benefit to depositors. What do we have? If we don't have depositors, we have shareholders. So more capital makes the shareholders, has, you know, more of a security base for the shareholders as you continue to add more and more capital. It also allows us to expand our business, do more FID-FIN transactions. Now, one thing I do want to clarify that I don't think is real clear here. The regulated and chartered entity is a subsidiary of the holding company. The technology platform and all of that intangible is not held. That intangible and goodwill is not held by the regulated entity. The regulated and examined entity has a very small intangible base on it, the one that they're to opine to when it comes to safety, security, and soundness. And that's done intentionally so as to simplify the regulatory examination process. That big intangible sits up top at a holding company. But Beneficient Fiduciary Financial is a subsidiary. I believe it has a very small intangible related to specific system in that entity that is necessary in order to operate the business. The vast majority of that entity is full tangible capital of the entity that's to be examined, tested, and so forth.
Thanks for the clarification. So the capital really is to, in your opinion, when one goes out and goes and gets more capital in the in that next transaction next year, would be to expand usage marketing capabilities to attract more FID-FINs, to enable shareholders to...
And to do more transactions. You know, let me give you an example. If we could do, expand our capital base by $1 billion in 2023, we'll put all that to work because the demand is, it's a tremendous demand. That's $25 million to the economic growth zones in the Department of Commerce.
It's not like this technology is sitting there and it's just an engine that can automatically, it requires capital to make these things work in some fashion or form.
Yes, you need to have the capital, and then that's tangible capital that gets put in the regulated entity.
Second question is around cryptocurrency. Are we at risk with some of the things that have happened in the last month or two? Cryptocurrency is kind of an alternate asset viewed by some. Do you engage in any kind of transactions that include cryptocurrency as part of those assets that can be liquid?
We do not finance the cryptocurrency. In fact, the law, Vice Chairman Kelly had, actually, I think it was you that scratched out cryptocurrency, and we were fine with that because the first draft of the law included being able to finance cryptocurrency. We don't. Now, that said, when you finance a portfolio that will include a variety of assets, most alternative investors have 1% to 2% in crypto. So you are having some level of financing, and so when we do the underwriting, that gets a demerit, a big demerit, to where we don't apply value against the financing we advance on that portfolio. We don't apply value to the crypto. So we're not exposed to FTX or BlockFi or any of those issues you're seeing over the last month.
Last question. Can't promise that, but last question would be, do you have any commentary on the captive insurance piece that we put in place?
Yes.
Has that been enacted in terms of what?
So we have our application ready to file. What we wanted to do, what we made the internal decision to do, is sit on the application. We have the funds to capitalize it in an escrow account, ready to capitalize it. That is not inside the regulated entity, BFF. It's underneath our holding company, sitting waiting to capitalize it. The application is completed. All the third-party necessary reports that you have to have, like premium evaluation reports from actuaries and so forth, those are all completed. We decided not to do that until we complete the process with the OSBC, because we wanted to be able to sit with the insurance commissioner and explain we're through this process, and if there was anything with the OSBC process that needed improving, we wanted to do that before we initiated the process with the Department of Insurance overall. So we're getting close to that. And the new one, as Deputy Commissioner Tim Kemp said, that we're going to kick off here in mid-December, and it'll roll for another 3 months. So we'll get a good feel here by mid-January, and February we'll go ahead and submit the application and begin that process.
Representative Kelly.
Thank you, Mr. Chairman, and this might be for Derek as far as when we get into the financial things. Do you see that this examination that's going to start in December and reach towards a conclusion maybe in January or so is going to create some things, and Brad mentioned it, that you may notice things that need to be changed in the examination from both sides, the company side and the OSBC side, so how you can do a better job at it together?
Yes, sir. I would not, that would not surprise me if that would occur. So there's been really good dialogue with the Commissioner's office and his team. And so with that dialogue, I would expect that we may find items as we go through the examination process that need to be changed and improved, whether that's statutory, whether that may be some of our policies and procedures, whether that may be some examination standards. So it's been a healthy dialogue, and I do expect that we could see some of that, which is, one of the purposes, obviously, of going through that exercise to begin with.
Okay, I was wondering if you saw it that way. It seemed to me like it would be that way since it's the first one.
Absolutely.
And since it's a completely different kind of entity, that it might lead to various types of changes.
I agree. And I'll comment too, something that Commissioner Herndon, testified to that I want to highlight, and that is, I believe the testimony was that, the pilot program may be concluding, and that's no small accomplishment, and particularly for the Commissioner and his team. It's taken a lot of heavy lifting and hard work to get to that point. We're delighted to hear that. And as the letter that Brad referred to that you have in your materials, we think that with that conclusion of the program that we'll be able to see more institutions coming into the state and expressing an interest. So we're excited to hear that and appreciate the work that has gone into concluding that program so quickly.
Committee, additional questions? I see none. Derek, thank you very much. Committee, we will now hear from Rachel Willis with the Department of Commerce on the activities of the TEFI Act.
Thank you, Mr. Chairman and members of the committee. My name is Rachel Willis. I'm the Director of Legislative Affairs for the Department of Commerce. Thank you for the invitation to share the latest regarding the TEFI Development and Expansion Fund, which is administered by the Department of Commerce. So the TEFI legislation created the fund, and it requires expenditures from the fund to be for the economic development projects within those economic development growth zones in the state, and for promoting and facilitating the development and growth of trust funds, the FID fund activities, and to locate trust banks office space within the economic growth zones. So after receiving the funding, Commerce developed a request for application, so an RFA, for a grant program titled SEED, Strategic Economic Expansion and Development. The purpose of this grant is to support the economic revitalization of Kansas communities under 5,000 in population through investments of quality life initiatives. The RFA was released Monday, August 29th, and we held an informational webinar, and applications were accepted through Friday, September 30th. The SEED grant eligibility requirements included things like projects must be in the area with a population of not more than 5,000 people located in those economic development zones. Applicants must be a county or municipal government, economic development organizations, local chamber of commerces, library systems, and then 501c3s or 501c6 nonprofit organizations. All the projects for the application had to fit within one of 4 categories. So that was community vibrancy, early childcare and senior programming, libraries, and then food retail. The projects had to be completed within 12 months, and construction has to occur within 4 months. The applicants could not have received a base or HEAL grant for the particular project, so looking for something new. Then all the funds used had to be for tangible things, so that it couldn't be used for strategic planning or consultant reviews, community conversations, or activities like that. The funding also could not be used to support one-time programming, so speaker fees, event fees, or salaries. And only one application per county may be awarded funding. So since the deadline, Commerce has received 109 applications with a total funding request of almost $4.8 million. So the department has completed our eligibility review, and we have just real recently finished our merit review. So the merit review examined the project description, the scope, the budget, the timeline, and pictures. Pictures were required within the application. And we also took into consideration any other kind of optional materials or information that the applicant provided. So with that, I will stand for questions.
Rachel, thank you very much. Committee, are there questions? I see none. Thank you very much.
Yeah, thank you.
Okay, committee, we are at a point where I'm going to leave it your option on whether you'd like to modify the agenda or not. After listening to the presentations, I think we have a couple of recommendations. The original agenda called for us to break for lunch and then come back at 1:30 to have discussions and to develop committee recommendations. We are a little bit ahead of schedule. I think we could possibly finish our work in the next 30 minutes if we wanted to do that. And then rather than taking an hour, 15 minutes off, is everybody okay with pushing through? And we'll complete. So everybody okay with that? Okay. At this time, I'm going to open it up for committee discussion. What we need to ultimately do is send a report to both houses with the minutes of what we've done, and then any recommendations that the committee would like to provide in that report as far as legislations or alterations. So a couple that I identified in testimony is the OSBC would like a bill that would help define officers and directors that would help with fingerprinting and background checks. Is that correct? Okay. Committee, is there any discussion on that? Everybody okay with providing a recommendation to look at that legislation? Okay. Brock, would you be willing to either draft language to send to the revisor's office or work with the revisor's office with my permission to get that drafted for introduction when we go into session?
Mr.
You've already got it. Perfect. A second request was a redefinition of the definitions for charitable definitions from Beneficient. Is there any discussions on that? Senator Pittman.
I think I don't want to make this as a recommendation until we understand more about what the problem is. I feel like they've made a good, genuine request, but maybe that's part of the committee process after this. But I certainly don't feel like we should go too far out of our lane here in terms of changing definitions of nonprofits too widely. I just don't see the need yet. That's my opinion.
Duly noted. Let me, this joint committee does not have the ability to pass anything. All we can do is make a recommendation. Any recommendation that we make for legislation will have to go through the entire process, committees in both houses, passes both houses, governor's signature. So I think whatever those recommendations could be, certainly there'd be opportunity to be fully vetted on any recommendation that we might make. So any other concerns or comments? Consensus of the committee that we should take a look at that? Okay. Thank you, Eileen, for that. This committee does not have the ability to introduce legislation, but we can make a recommendation. I think I can, as a legislator, I can, this committee can, okay. Yeah. Representative.
Thank you, Mr. Chair. I echo what Senator Pittman said on this particular one, especially as it relates to the federal tax code, and then essentially we're expanding it to more. I would just like to get a better sense of what types of organizations are currently tax exempt based on that code, and then what this opens it up to.
Okay. Any additional concerns or comments? Does the committee want to take a vote on that recommendation? Those in favor of putting that as a recommendation signify by saying aye. Aye. Opposed, no? No. I believe the ayes have it. You wish to be recorded also? Are there other recommendations that the committee would like to see in the report? Senator or Representative Kelly?
Thank you, Mr. Chairman, and this may be a longer way to get to a recommendation, but I've thought a lot about this, and then after listening to the testimony today, I still have my concerns about the authority that TEFI legislation gives the OSBC to actually conduct a review that is truly comprehensive enough to allow them to properly issue an opinion on safety and soundness. And no matter what an organization is, how it's set up, I think safety and soundness have to be determined if it's a financial organization. And having spent my entire working career in the banking industry, I've developed actually an appreciation of the benefit of examinations, that what they provide for the protection and confidence of our financial system, the protection and enhancement of the stability of our financial system, and the protection for our customers, consumers that put their trust in the financial organization they're dealing with. In addition, these in-depth reviews, and it was mentioned today, provide opportunity to tweak or fine-tune their systems and operating procedures and learn as the examinations go on. Kansas chartered banks and trust companies have relied on the OSBC for decades to conduct fair and comprehensive reviews of their organization. Now, with TEFIs occupying a new third lane in the financial marketplace, I do not believe the OSBC has the authority in current legislation to truly conduct this same type of fair and comprehensive review. Thus, I do not believe the OSBC will be able to provide the same level of confidence to the market, the public, and TEFI clients with the tools they now are authorized to use. I'm well aware that we're told that TEFI customers are very financially sophisticated, but I don't believe this should mean that the public or the Kansas financial system are owed any less regulatory insurance about this new third lane of the Kansas financial system than the clients of Kansas banks and trust companies, which also have a sophisticated customer base and have had the benefit of the examinations for themselves and for their customers and for the public for decades. I did have an amendment that I'd prepared to contain changes that I believe will allow for the OSBC to conduct a review that will enable them to give greater assurance of the safety, soundness, and stability of the new third lane. However, since I will not be here in 2023, after a lot of thought, I've decided not to offer this amendment and leave the consideration of any needed adjustments that will enhance the safety and soundness and confidence in TEFIs to the 2023 legislature. And as was noted really by both the Commissioner's Office and by Beneficient, that the first exam will tell a lot of what might need to be done. I do have copies of my amendment that anyone that's interested in looking at it after the committee adjourns can get. But therefore, instead of offering the amendment, I'd like to ask that a recommendation be included in the Joint Committee report for the Senate and House Financial Institutions Committees to review and consider in the 2023 session any needed revisions to the regulatory review section of the current legislation in committee, and if determined that there are some, recommend from the committee to the full Senate and House the amendments necessary to bring TEFI examinations up to the same caliber as those that our Kansas banks and trust companies will have and have had for decades. So know that both Derek and the Commissioner's Office talked about this will be a learning experience, and I would just like to recommend that we put in the report that from this learning experience, the committees look at any needed changes to, we can't necessarily look at all policies, their company's policies at all, but any necessary legislative changes that may be made with an eye in mind that we should work toward. I think that our Kansas banks are 200 and plus Kansas banks, and the trust companies should not, in my mind, be put at a higher standard than the TEFIs. So to work towards some type of ratings, and these examinations will help to do that, that will provide some true financial security and stability to the public and to the state as to the examinations can be at an equal level or an equal par. I'd like to say, since this is my last meeting for this, it's been an honor for me to serve for the House Financial Institutions Committee and have the opportunity to work with many of you and such wonderful staff these past 12 years, trying to ensure a safe, sound, competitive Kansas financial system that legislators, our state, and the customers of our Kansas banks and trust companies and TEFIs can receive assurance from and be proud of. And so therefore, I would like to, as noted, have a recommendation that the committees, House and Senate, look at the TEFI exam procedures and all, and use a basis for that of what's come out of this first exam. And again, I thank each of you for your service to our state and your friendship over these last 12 years.
Thank you, Chairman Kelly. Committee, is there any comments or discussion on the recommendation from Chairman Kelly? So as I envision that process, would both Ben and the OSBC, once that examination is complete, would you be willing to come back to committees and discuss any tweaks or changes in legislation that you feel would be appropriate based on the completion of that first examination? Okay. Yes, let me clarify that, because we will not be able to talk specifics about proprietary information within that exam. But if there are things that either the OSBC has discovered that would make the examination process easier, more complete, better information, or vice versa, if Beneficient sees things that they have concerns about or changes they would like to make, then we could have presentations from both parties and we could consider legislation if deemed appropriate by the committees at that time. So is that recommendation somewhat clear?
Mr. Chairman, I believe so. What we could do is state that your committee report be directed to the standing committees on financial institutions in the House and Senate. Then it would state that those committees are requested to review and consider any necessary changes to the regular review section of the TEFI Act and to incorporate any public findings or responses by either the OSBC or Beneficient to the examination process and lessons learned in that process to those committees for determination whether legislation needs to be advanced to the full House and Senate.
Committee, do we have consensus on that?
If I can, Chairman, I just want to say the overall goal, as you mentioned, is to come we evolve into an examination that provides more information, more assurances to the public and to the state and to the companies and all, that we have a true picture of the TEFIs and that we have tried to, in the way possible, identify safety, soundness, and all, that we evolve into a process, and it'll probably take a couple exams, but that will allow us to have that confidence for the state's financial system.
Certainly. Committee, are there other recommendations or items that you would like to see in the report?
Mr. Chairman, this is Representative Owens, if I might interject.
You may.
Thank you very much. Raising my hand hasn't worked out so well. I just wanted to take a minute. I don't have a specific recommendation, but I certainly wanted to take a minute as I've listened to this meeting start to finish and have seen the interaction and really seen a very different tone of this meeting versus previous meetings and previous interactions. And I just truly wanted to commend the OSBC, their staff, Beneficient and their team, as well as the members of the committee, on the progress being made in this industry. We're finally starting to see some very tangible results, and I'm just very excited to see the progress that has been made, and wanted to thank the OSBC for their work in doing so.
Representative Owens, thank you for those comments. Senator Fagg, did you have something?
Thank you, Mr. Chairman. A couple things was on my mind. Number one, I had the opportunity to go to Heston and walk down the street. I don't think Brad did it justice. I think we will be so excited and impressed with what we're doing there in rural Kansas and what we're trying to do. So I want to commend Ben on this thing of what they're doing and thank each and every one of you for the foresight of where we need to go with this. So I wanted to be sure and bring that out. The other thing is that as we add to this, to me, timing is of the essence. So we've got to cross our T's and dot our I's. But as we go through the examination, we come out of that, we need to, I think there's other states that I'm sure are looking at what we're doing here, and we need to be very proactive in making this happen and be sure and keep the attitude of working together. So we all want the right thing, and I think we can do it.
Thank you for your comments. Any additional comments or items that you'd like to see in the report? Melissa, do you feel like you've got enough direction?
I do, Mr. Chairman. Does the committee also wish to comment on the status of the charter and the application being recognized as complete by the State Banking Board, and that the pilot program has been recognized as concluding, and the status of where those exams are with the 2 targeted exams and the 3rd scheduled? You previously commented on the status of the charter in your last report, and I didn't know if you wanted to then comment on the progress report or separately on the progress of the economic growth zone now that FIDFIN transactions have commenced.
I think since we've had testimony on the completed audits, we can certainly talk about that. We can mention that the requirement of audited financials have been submitted. And so kind of a, when we review the testimony from both OSBC and Ben, those would be items that I would anticipate being concluded. Okay, last chance to include something in the report. I don't see any, so I would like to take the time to thank the OSBC for their work and for being here today. Hope you found it valuable. We certainly have. I want to thank the people from Beneficient for being here, and I want to thank Rachel also from Department of Commerce for being here. Would like to thank our research and revisor staff. There's a lot of work that goes into putting these interim meetings together and the agendas, and as always, they way outperform the expectations, and so they continue to deliver great work. And I want to thank all of you for being here today, and I'm sorry that we're going to adjourn about 3 hours early, but that's the way it goes. We are adjourned.